Well, good morning, everybody. I want to thank you all for coming this morning. On behalf of Amerisure and the Sterling Insurance Group, we welcome you. Today we're going to go over one of the things out there in today's society that's obviously on everyone's mind. We have the big election coming up in November with the possibility of taking marijuana to a recreational status here in the state of Michigan. And as employers, we all have questions around, if we have accidents in the workplace, if we have OSHA obligations to report things certain ways, what is the story on that? So today we're bringing you Paul Richards from Amerisure. Paul is one of the legal representatives from the company, and also Todd Bernardoni, who does the loss control and risk management for Amerisure. So I'm gonna let these guys take over and kind of take you through the entire OSHA requirements and medical marijuana that's here in the state of Michigan. So Todd, you lead us out.
No. I can hear myself again. Okay. All right. So yeah, we're going to understand the rule. We're going to talk about that, and then we're going to need the need for continuing to track the OSHA recordable injuries. Nothing is changing as far as the need or what we need to track as far as an individual company, but some of the online reporting has changed. So we're going to talk about that. And then some of the future timelines for submitting these data for this information to OSHA. We're going to talk about that as we go further along in this presentation. So some background about the rule. The final rule became effective on January 1st, 2017. So OSHA is taking information that is already required. So a recordable injury, hospitalization, fatalities are all still requirements. So we're taking this information, and they're collecting it electronically so that they can do a better job as far as formulating information and doing tracking and trending. Again, the new rule does not change anything from the 2002 OSHA Recording Act. The electronic submission data will allow OSHA to better formulate their compliance and strategies. They can have this information electronically. They can do pivot tables. They'll be able to have a greater understanding of the OSHA or the recordable trends, injury trends that are happening out in the workforce. So some of the desired outcomes, they want to encourage employers to increase their efforts to prevent workers' injury and illnesses. So by requiring these OSHA electronic record keeping, it's going to, again, compel, by the competitive nature of companies, to do better than their peers, right? We all want to be the best safety record for our different organizations. So if we're going to be tracking against our industry peers, we're going to be able to see what the safety recordable rates are. This is going to give us almost like a gamesmanship as to trying to do better with our safety record. It's also going to enable researchers to examine the data. The more data we have, the better we can formulate new OSHA standards. We can compliance initiatives, training initiatives. These are all things that we can utilize based on this data. So again, this is going to allow us more data to to be able to define our safety programs and protocols. So OSHA will post the establishment-specific injury and illness data it collects under the record-keeping rule on OSHA's website. So every year there'll be an updated information as to all the information that we're going to be providing from a company standpoint as far as our record-keeping, and we'll be able to see that on the OSHA website. State-operated programs such as Michigan, they have to follow the exact same rule. It's going to be underneath the Michigan, the LARA Act. We'll be submitting it the same way, just like all the federal states would as well. Okay. So employer, when we gather this data or we see this data on the OSHA website, then we can use that as a benchmark for our own safety performance. We can utilize that in compliance or in a relationship with Sterling and Amerisure. We can develop safety programs. We can develop safety training programs, things that will help minimize our loss, minimize our injuries in our workplace. Okay. But keep in mind that not every workers' compensation claim is a recordable. First aid injuries, these are, everything does not necessarily mean it's a recordable. So none of the reporting requirements have changed as a result of this new Electronic Record Keeping Act. Some of the things that the rule wants to make sure that we reiterate is that we're free from retaliation. And this is a basic rule underneath the OSHA Act that every employer has the right from retaliation. So we want to make sure that we inform all of our employees of our record-keeping requirements, that they need to report all injuries, that they're going to be free from retaliation from reporting an injury. We want to make sure that they're reporting all of our injuries, no matter how minor, so that way we can make sure that adequate medical attention and corrective actions can be put in place as a result of any injury. We don't want to utilize this Electronic Record-Keeping Act as a means for discouraging people from reporting injuries. We don't want to be chasing a number. We want to be doing what's right and keeping everyone safe. Severe injuries must be reported just like we currently do. So if we have a worker fatality within 8 hours, we have to report that to OSHA or my OSHA here, Michigan OSHA here in Michigan. Any amputation, loss of an eye, hospitalization of a worker, we need to report that within 24 hours. We have to talk to a person. We can't just leave a message. We need to make sure that we have that contact. Again, for state plans, Minnesota, Michigan, we have to use our own reporting numbers. Unless it's after hours, then we would report that to the federal OSHA field office. And then also certain machinery type injuries. So if we have something that's related to a press brake, point of operation, these are all focus plans underneath the OSHA reporting information. We need to do that directly to OSHA within 30 days using their online form that they have. Some other key information: if you were previously required to keep records, meaning if you had employees over 10 people over the course of the year, you're still required to continue to keep your OSHA records. Continue to post the summaries in February of each year. Again, we still need to report any fatalities, hospitalizations, amputations, loss of eyes to OSHA. And then we also want to make sure, and not only yourselves, but through Sterling and Amerisure, we'll keep an eye for any update. As we know with any OSHA standard, as changes come out, addendums and revisions occur. So we'll keep you apprised of those as they come up. And then post-accident drug and alcohol testing in certain circumstances, we can follow that, but some of the things that Paul is going to be talking about, it can be considered retaliation, so we need to make sure that we're following the drug testing policy that OSHA is in the process of changing as well. So the online reporting, now we're going to talk a little bit more about the actual online reporting. So any employer that has 10 or more people working in their facility over the course of a year, they fall underneath this rule. Again, just like it was since 2002. We have to report our injuries. The records need to be kept whether there was a death, injury, lost work time, restricted duty, job transfer, illness, or any other type of injury beyond first aid. This has not changed. The annual summary must be posted using the OSHA format, which I have. I have a sample of it here coming up in just a few slides. If you don't have any deaths or injuries or illnesses, you still need to post a summary, and then we need to make sure that we're keeping those records for at least 5 years, just in case of an OSHA audit. So now the new rule as part of the 1904 electronic submission part. So if we have 250 or more employees working with us at any time during the calendar year, in 2017, all you had to do was submit the Form 300A. Starting in 2018, we were required to report our 300A log, our 300 log, and our 301 log. And I've got a sample of those here coming up in just a second. And then in 2019, by March 2nd, we need to make sure that all those logs are submitted electronically on the OSHA website. If we have 20 or more employees, but less than 250 employees over the course of a calendar year, then, and our establishment is part of the Appendix A, which I'll show you here in just a second, some of the different class codes that fall underneath this new rule. As in 2017, we had to just submit our Form 300A. In 2018, again, still 300A, and then by March 2nd, we need to make sure that that 300A log is submitted electronically on the OSHA website. So here's an example of the 300A. Probably everyone in here has seen the 300A Form 300. I'm sorry, this is 300. And then our 300A log are the one that just of the injury or illnesses that happen over the course of a year. And then here is our injury and illness report, our 301 log. Again, if we have 250 or more over the course of the year, then this would be the forms that we would have to submit by March 2nd of 2019. Any questions on these forms? No? Okay. So Appendix A, like I discussed, if we fall underneath any of these class codes, the employee limit does not apply. We have to submit our electronic forms to OSHA. So, and it's in your handout that you have, because I won't run through all of these because as you'll see, this is just the first part of it. But some of them are skilled trade, manufacturing, construction, any type of utility work, sports, postal services, sports fields, schools, or any other types of employers. These are all industries that if you fall underneath these set class codes, we would have to submit our forms to OSHA electronically every single year. So where do we go to sign up? OSHA's website, www.osha.gov. It'll take you to the injury and we'll go to the injury and illness page. It'll look just like page. We've got a link to it in your handout as well, to the injury and illness index report. There's 3 different options that we can utilize for submitting our information that we're required to by OSHA. We can manually enter it into the web-based form that OSHA allows us to have or provides to us. If we have documents that we've already used internally, we can upload that file after we have created an account. And there's also an automatic system. We'll have the option to submit that in an API format. Thankfully, we have a way that we can test our file before we submit it. So we make sure that we're submitting the exact information that is required and that the file goes through in a proper way. Some common questions that we get about the new rule and reporting in general is if we have part-time or seasonal workers, do they count in the criteria for reporting in the course of a year? And the answer to that question is Yes, any individual that is on our payroll, whether it's seasonal, part-time, full-time, they would count in our head count for employers over the course of that year. The other question we get a lot would be, how would OSHA notify me if I need to submit the injury and illness data that we collect? And they're going to notify you in a couple of different ways. One, there would be a letter sent out to your organization, and then also it would be on the OSHA website would also notify us whether or not our class code would be determined as a class code that would have to submit electronically on an annual basis to OSHA. Any questions at this point on anything that I've talked about up to this point? Yes, ma'am.
Referencing? Oh, hi. From what I'm understanding, not everyone is going to get a letter. Is that correct? That does have to electronically report?
Outside of the 250 or the over
Right.
20, if it's one of the class codes,
There you
outside of those, then they would
So
send you a letter. Yeah, not
that's-
everyone.
Okay, because
Yeah,
that's
every company isn't going to get a letter.
Okay.
You're correct. Hold on.
I just wanted to clarify, when you say temporary companies that you hire for temporary workers would have to fill out their own OSHA log. We
Yes.
wouldn't have anything
No,
to do with it. Just wanted to
this
clarify.
would just be seasonal people that you hire. Correct.
You mentioned that the states are going to be required to comply in the same way and have electronic filing.
Yes.
Do you know when Michigan is going to have that requirement? When they're going to start doing the electronic filing?
I believe it's live for 2019, but I'll check on.
Yes, but he said earlier that it would be state required for, yeah. No, I mean, is there going to be a separate Michigan MyOSHA filing section?
Yes, so we would file in Michigan under the Michigan.
Under Lara,
Yes,
yes.
that's where, and I'll double check, but I believe that's live for 2019.
Okay.
You mentioned Michigan and Minnesota as being state plans. What about Ohio, too?
Ohio is,
Or that-
I'll have to check on Ohio, because
Okay.
that's a state plan, and I'm not sure about the requirements that they have in there, but I can definitely get you that information.
Okay, and this is a loaded question.
Okay?
Well, what's the penalties for non-compliance on the reporting side?
It would be OSHA penalty. It could be a serious penalty, so I think up to $10,000 fine.
Per violation.
Sorry, I have all the questions.
Oh, that's okay. I like it.
So if you have an employee that was injured and they're still seeking medical attention after March 2nd, are you going to be able to go back and amend the electronic version of what you've submitted?
Yeah, it would be just like our normal logs where we can amend it if, with days away from work, where we can amend it to where, if we reach our cap or anything like that, or below our cap.
Okay.
Great questions.
For our clients, the Sterling clients, I just wanted to point out that we have, as part of our portal, we have a record-keeping tool in there. And the nice thing about that is you can, if you have different locations, everyone can report into this tool, and then it converts it into the CSV format, which is required to submit on their website. So it's a really nice tool. So, and if anybody would like training or would like some information, just let Lindsay or I know, and we'll do that. So.
Great. Any other questions? Okay, then I will turn this over to Paul Richards. There you go, sir.
Thanks, Todd. And thanks for inviting me. I mean, this is a very interesting topic from a legal perspective, and obviously as employers, you're going to have to deal with what looks like recreational marijuana is going to be, unless the polling is all off, is going to be approved on November the 6th. So this is going to become more of a pressing issue as employers in dealing with, prospective employees or employees who may be using marijuana either medicinally or recreationally. Of course, since I am an attorney, what do you start with? The legal disclaimer. And basically, this is a presentation, and you have all this material in your handouts, but this is for general information. If you've got I'll be happy to answer any questions, but if you really have a specific issue or question dealing with your particular situation or your business, you probably need to consult your own lawyer just to make sure that what you're doing is legally sufficient for your own situation. We're going to talk about the 2008 legislation. So this is nothing new. That's medical marijuana. That was approved by a vote of the people in 2008. How the federal government views marijuana and how they spell it. You're going to see marijuana spelled by the statutory material with an H, because apparently in 1930, when they started regulating marijuana, they were afraid that nobody who didn't understand Spanish would be able to say it right. So they put it marijuana as opposed to marijuana. How testing works, what kind of questions that have come up. Some have been submitted by you through the Sterling folks. Why Amerisure is interested in the impact on insurance, and some practical problems that may be presented to employers as a result of the utilization of marijuana, either medicinally or otherwise, and what steps as an employer you can take to protect yourself from having impaired people on the job and creating dangerous situations. And you can stop and ask me questions. We're going to have a Q&A thing towards the end, but if there's something that I have articulated or misspoke, which is possible, or you just have a question about anything, feel free. I know there's a microphone. You can certainly stop me and ask me a query as we're going through the presentation. New in 2008, this is medical marijuana, which has been around for a while, 10 years. And marijuana, you can use it for medicinal purposes if you've been diagnosed by a physician as having a debilitating medical condition. Well, in the next slide, you talk about the debilitating medical conditions. There's a lot of them. And I can pretty much assure you that if any of you went to get a medical marijuana card, you're over the age of 30, and you said, my knee is bothering me, you could get a weed card. And just about anybody could get one. There's not a huge leap to get over to get a medical marijuana card. But the statute does say, or the law does say here in Michigan, you can't be under the influence of marijuana and do anything, drive a car if you're high, be in the workplace and be high. One of the issues, and we'll talk a little bit more about this, is how high is high? I mean, what measurements do you, because marijuana, unlike alcohol or other drugs, is metabolized a lot differently. If Todd and I had smoked a joint last night, we didn't. I mean, Todd might have, but I didn't. And we came in today, and we weren't, obviously impaired. He could test positive for weed. And if I was in his car, and he was smoking a joint, and we were enclosed, I could test positive. We're not high now, but and that's one of the real issues, and we'll delve into that a little bit more, is to makes it difficult to determine, what do we do if I've got a post-op or drug test that is positive for marijuana, or there's a post-accident test that's positive for marijuana? As an employer, what steps can you take? And we'll talk a little bit about that. Again, under the influence is the key when you're talking about, what do we do from a legal standpoint? And that's one of the real difficulties in determining what's appropriate as an employer when somebody either tests positive post-offer, pre-employment, or after an accident, or on a random test. And again, look at the things that you can do. You're a green contractor. Now it might have a new meaning as opposed to somebody who's just energy efficient. And again, you look at the debilitating medical conditions. I mean, all these add up to more than 100% because some people have more than one, but look at the primary one, severe and chronic pain. How do you measure that? You know, my back hurts almost every morning. And so, like I said, getting a weed card is not difficult. But these are the conditions that are deemed debilitating medical conditions so as to fall within the parameters of permissible medicinal use in the state of Michigan. And marijuana does have some medicinal purposes, and it is primarily for people who are treating for cancer, or you do have severe or chronic pain that's related to some other medical condition. So it isn't as though people that utilize it medicinally are all just trying to get stoned. It really does have some medicinal purposes that can help people deal with some chronic conditions. The federal government, however, views marijuana, and you'll see how it's spelled over here with an H, like heroin, LSD, and cocaine. And it's been true for many, many years. So it is still illegal for any purpose under federal law. The federal government has kind of taken a hands-off approach to individual utilizing, or individual states either legalizing marijuana for medicinal or recreational purposes. However, it is still a Schedule I narcotic and under federal law, which complicates lots of things with regard to how it's regulated locally, and as an employer, what does it mean for you? Has medical marijuana and has for 10 years. And in November, there's going to be a determination as to whether recreational use is going to be permissible. And like I said, it appears that it's likely to pass. There's some federal laws that I suspect some of you may have to comply with. This Drug-Free Work Effort 1988, again, this was part of the Just Say No campaign during the Reagan administration. And it's a good goal. I mean, nobody wants to work next to somebody who's under the influence of anything, whether it's alcohol, marijuana, or any other drug. And it discourages drug use among federal employees and employers that have federal contracts. What it doesn't do, though, is mandate any drug testing. It encourages contractors with federal government contracts to encourage a drug-free workplace. Typically, the only way you can do that is to drug test people. But there's nothing in the Act itself that mandates drug testing, and there's nothing in the Act that says you got to fire people who test positive. You just have to get them off the job site if they're high. And again, if you're doing stuff in transportation, interstate trucking, the rules are different. Then you do have mandatory drug testing for somebody who's driving an interstate truck or doing other things that are, if you're working in a nuclear plant or doing other things that the federal government views as dangerous, not just to the individual, but to society in general. So there are different rules for DOT-regulated businesses, and that's the primary one where you see basically a zero tolerance. Somebody who tests positive for marijuana or cocaine or alcohol is, if you're operating a 18-wheeler, can be a significant danger to the public. So there are some different rules under the federal rules or federal law for dealing with DOT-regulated industries. Can you test? The answer is yes, in most situations. For pre-employment, you can test. Pre-employment as in after an offer, post the person or prior to the person actually starting to work, and post-accident situations, you can still test, even under the new OSHA regulations, 1904. But one of the things that OSHA has done is said, well, you can't, if you only test the individual who's injured, there's a possibility that people won't report their injuries in a timely manner because they're concerned that they're going to be disciplined for smoking marijuana or ingesting marijuana, but they're not impaired at work. So there's some view by OSHA, and it's not actually the regulation itself, but it's in what OSHA views as their interpretation of the regulation, that if you do have an on-job accident, you should test everyone involved, not just the injured party. So that if you end up with a forklift operator who runs into a co-employee and then hits the wall, and there are 4 people that were involved in either witnessing it or were involved in the injury. But the only person injured is the one that got hit by the forklift. The operator's fine. To comply with the OSHA requirement with regard to anti-retaliation, you should test everyone. The person that was injured, the person operating the forklift, and any witnesses. Simply to protect, so we're testing everyone. We're not going to simply test the individual that was injured. And that way there's no violation or potential violation of CFR 1904 dealing with reporting timely injuries or reporting injuries timely. So again, do you have an objectively reasonable basis to conduct the test? That's the standard in the regulation. Is it reasonable to conclude that drug use contributed to the accident? And again, when you use words like objectively, reasonable, these are full employment acts for lawyers. What does that mean? Generally speaking, it means what observable behavior would somebody looking at the parties that have been involved in this accident, what were they doing? Were their eyes all bloodshot? Were they stumbling around? Were they acting weird? Something that you could say, well, we had reason to believe that there was something going on with this person. Was it right after lunch, after people had gone to the bar, or something along those lines? And again, were all employees involved in the test or just the person injured? Or is the work performed safety sensitive? And again, operating a forklift in an area where it's confined space could fall within that definition. So there's a lot of things that are probably going to be the subject of either further interpretation by OSHA or litigation in dealing with, well, why did you test me for this, and why didn't you test somebody else, and why do you only test the Hispanic people or the African American people and not the white folks? I mean, so if you're applying the rules and you have a policy, you need to apply it in an even-handed manner so everyone involved, irrespective of some immutable characteristics like gender, race, along those lines, is subject to the same policy. So you don't have somebody saying, well, they're only picking on me because I am whatever, female, a male, Jewish or Catholic, something along the lines that would make somebody say, well, they don't apply this in a fair manner. And you can certainly you may have to somebody challenging the validity of not only the test, but why you impose the test. Again, problem with testing, I touched a little bit on this, is marijuana is so differently metabolized than alcohol. Winston Churchill, a famous joke that said, some woman came up to him and said, "Sir, you're drunk." Churchill said, "Yes, you're right, ma'am, I am drunk, and you are ugly. And tomorrow I will be sober, and you will still be ugly." But that's because alcohol is different. I mean, within a few hours after, being legally intoxicated, for which there is a standard, the alcohol is metabolized by your body and you're sober. You might not feel very good, but you're not going to be under the influence of alcohol. Marijuana is different because an occasional user, somebody who smokes on the weekend, will test clean in about a week. Where if you have somebody who smokes a little bit every day, it could be months before they're going to test or they're going to not test positive. And so it depends on what you do. Do you eat it? Do you smoke it? Do you use it in tea? I mean, there's a lot of different things. And if marijuana is legalized in the state, just based on what we've seen in Colorado and Washington, which are the two states that have had it legalized for recreationally the longest, you're going to have shops that open up that sell candy. If you've been to Denver or any place in Colorado, they're all over the place. Candy, teas, brownies, I mean, stuff like that, edibles. So it's not just stuff that's smoked. It's just different in the way it's metabolized. It's metabolized more slowly if you smoke it, and it's metabolized a little more quickly if you eat it. So there are going to be issues with regard to what level do we test for, and is there a level of impairment? And right now, the answer to those questions is, yeah, you can test for it, but we can't tell if there's impairment. Yes?
This seems to be the biggest issue going forward. This seems to be the biggest issue going forward. Where do you see it where, like, if I get pulled over and I'm drunk, they can give me a breathalyzer and tell me I'm drunk? Where do you see the blood test come in play, or is there something that comes in this play that says, hey, this guy looks like he's stoned?
Yeah, I mean, one of the problems, I mean, that's an excellent point, and even like 0.08 blood alcohol level for legal intoxication is an arbitrary number. I mean, it's a number that if you had somebody who was a consistent, highly functional alcoholic, they might always be like 0.04 or higher. Whereas if you had somebody who, drinks once a year at the Christmas party, they're at 0.04 and they're passed out on the floor. But to your point with regard to, is there a test? There isn't a test. I mean, they can tell the presence, you've been exposed or you've ingested or been around or inhaled marijuana or the smoke from marijuana. There's no test developed yet that will apply like a BAC, a blood alcohol test does. And so one of the things I think as an employer that would be important would be, and it goes back a little bit to that 1904 objectively reasonable standard, is what did the person look like? What were they doing? How were they acting? Did they act like they were stoned? Or were they just, you didn't observe any changeable behavior or any behavior that would reflect this guy is recently been smoking. Well, I think if you, and again, if somebody, and the metabolites for marijuana are, you can tell, to some degree, well, there's this much in your system or there's this much in your system. The question is, where's the impairment level? And that's something that there is not a test for as yet. So I do think that if you were to say, you know what, everybody saw the guy's eyes were bloodshot. He was eating Cheetos like crazy. Or something along, you were active, you were impaired, your motor skills were impaired. And it was different than what you may have seen in the same individual the day before. I think then the closer you get and the more behaviors that you can demonstrate, and there's something going on that's not normal. The more likely you're able to sustain if you were to challenge, why'd you do this? I should have been fired. It isn't fair. The fact that, I may smoke a joint on the weekend and now it's Tuesday doesn't mean that I should be fired. Having said that, in the absence of a unionized environment and the appropriate policy, and you've got a copy of a sample drug testing policy in the back of your materials, as an employer, if you said, you know what, I don't want anybody who smokes weed, it's an illegal substance, it's federally Schedule I narcotic, working for me, you can fire somebody who tests positive. You can refuse to hire somebody who tests positive. The issue that I think, and that's from a legal perspective, in the absence of a union contract, because drug testing is typically going to be a mandatory subject of bargaining with your union, if you're in a unionized environment. If you're not, and you opt to say, I've got a zero tolerance for marijuana or any other drugs, you can do that. There may be practical reasons that make that difficult, because right now in Michigan, the estimated population of regular marijuana users is about 15% of the population. That means 85% of the people aren't smoking weed every day or on a regular basis. But 15% is pretty high. And if it's utilized recreational, legalized recreationally, that percentage may go up. It may not go up to 85%, but it may go up to 20 or 25. Or it may stay relatively the same. I mean, as soon as it becomes legal, I don't think people are going to be running to the weed shop, but you never know. But you could have a zero tolerance for it as an employee. Be who's impaired and how are they impaired. Yeah.
So I'm trying to apply this to, to our own situation. We currently have a policy that states that anybody who is a driver, a non-DOT driver, because it's a bona fide occupational qualification, that they are in a safety-sensitive position, that they cannot test positive for marijuana. So legally, that would be acceptable.
Yeah, it is. And I would assume that same policy would say you can't show up and operate a company vehicle under the influence of alcohol or any other mind-altering substance. So if somebody were to show up stumbling around smelling of beer, they're out too. I mean, there's nothing wrong with any of that. I mean, the whole idea is, if I'm working in a industrial situation, and Todd's working next to me on a plant machine thing, I sure don't want him high. Okay, yeah, let's hit the button and see what happens. And now they're calling me left because my right hand got chopped off because of double cycle. There's something along those lines. Who's in any type of work environment doesn't want to work in an environment where it's unsafe because somebody's stoned or drunk. So as an employer, you have every right to a zero tolerance or a zero to ensure that you've got a safe workplace, or safe enough for as safe as possible, so that if there are accidents, which obviously will occur, alcohol or drugs won't be the cause or a cause. Again, is it legal to use weed in the workplace? No, it's not. And there were some other questions that were submitted to the Sterling folks. You can basically, again, it's a union environment, not hire somebody who qualifies or who tests positive for marijuana after you send them for a drug test or after a job offer. You can implement a zero tolerance policy. And post-accident, again, subject to the OSHA regulations. If you have an objective basis to test, you can test. And if somebody tests positive, they can be terminated, irrespective of whether they were impaired or not. One of the other questions was asked, well, what if somebody tests positive and it's a work comp claim? In Michigan, misconduct by the employee is a disqualifying event. If somebody engages in misconduct and injures themselves or is injured as a result, you're not eligible for comp. There's been some comp cases in which the question was raised, well, this person was involved in an accident, they tested positive after we gave them a drug test for marijuana use, and the work comp appeal board concluded that in the absence of showing the person was impaired by the utilization of marijuana or any other drug or alcohol, it's not a disqualifying event. And again, this all stems back to, well, what's impairment? How do you determine whether somebody's impaired at the time they were involved in a otherwise compensable injury under the Work Comp Act? And that's where the objective observations of the behavior are important. Yeah, this guy tested positive for weed, and it was whatever level it was, but there was no indicia that he was impaired. On the other hand, if the same level of intoxication or same level of THC is the active ingredient in marijuana that is psychoreactive, if that's there and somebody, again, was stumbling around, slurring their words, bloodshot eyes, that becomes more and more likely like they've engaged in misconduct so as to disqualify them from receiving work comp benefits. Again, just about anybody who really wants a weed card can get one. You can. That doesn't mean, and if somebody's got a card and they acknowledge that, I use marijuana to, deal with my chronic back pain or my epileptic condition or some other thing else, that's okay. That doesn't mean you have to hire them. Just because they got a weed card doesn't mean that you have to hire them if they test positive, or they just tell you, look, this is one of the medical conditions I have. That's where you can run into problems, because if you're going to have a policy that says we don't tolerate marijuana use, in any of my employees, and then somebody, this person who's got a card is your best salesperson or your best whatever, and then somebody else comes in, and that's when it's like, you have a policy that you don't apply evenly. You only apply it when it suits your purposes. And again, if the person that is being told we're not hiring you or you're fired happens to be in a protected classification, i.e. race, sex, that type of thing, you've probably exposed yourself potentially to a wrongful discharge or some kind of discrimination claim. So you can have the policy, but if you don't apply it evenly, that's problematic. Yes?
Sorry, if you have a question, please raise your hand. We're trying to get all questions on the live stream. Thank you.
Okay, so we have in our policy set up that if they can provide a legitimate prescription to the testing facility for the substance and if they're within the tolerances or the limits of their prescription, then that comes back as a negative test. What our stance has been on this is that this is not a legitimate prescription. This is just a card that allows you to possess and use on your own time. Are we in murky water there with that?
No, I think as long as you utilize, because it's illegal federally, I suspect your policy says something if you're under the influence of any illegal drug or something to that effect. And it is federally illegal to use or possess marijuana.
Right. So, yeah, that's a good point. And I think because there's some opiates that are prescribed for ADHD and that kind of thing that will test positive on our 10 panel, but are actually legitimate prescriptions.
Correct. So as long if it's a legitimate prescription and it's not federally an illegal drug, a la marijuana, then you will have no problem with that, in my view.
You had mentioned alcohol. If someone drinks a lot, they have a different level possibly. What about the stoner that wakes and bakes, every day?
It's the same thing. You can, and because marijuana hasn't been, because it's a Schedule I narcotic, it has not been studied. The influence of, what happens if you really do have a brownie laced with marijuana every morning instead of a bagel? And so are you high all the time, or is that just something that your body's adjusted to? That's a good question, and I don't know the answer to it, and I don't know if there is a specific answer, but it wouldn't surprise me if it's the same effect in the sense that I take this every day. I'm not objectively engaging in behavior that would make me feel, or be observable that I'm under the influence of anything. This is just what I do every day.
Right. I guess the other question is, I'm going to tell my 18-year-old to become an attorney to defend, people in the workplace for weed, because it's going to be a growing industry.
That's right. At least what's going to happen, I suspect, is the law is going, the law is going to react, assuming that recreational marijuana the proposal is passed. There's going to be a probably 5-year period where people figure out, okay, how is the law going to really treat this? Are we going to develop a test, or will a test be developed that will measure impairment, similar to what we have for, alcohol? Is there going to be a BAC is blood alcohol content, let's say MAC, marijuana, whatever, content? is there going to be a test along those lines where it's just going to be an arbitrary number? If you test above X, you are impaired, irrespective of whether you're stumbling around or whether you're, appear to be completely sober. But in the short term, there really isn't a whole lot of medical information as to how to measure impairment. We can test for presence of the THC, but there is no, at least not yet, a test which would say, yep, this person is stoned and shouldn't be driving a car, shouldn't be doing anything other than sleeping it off someplace. Again, why do we care? Why does Amerisure care? Again, and this is true with any mind-altering substance, but it's linked to accidents in the workplace. What a surprise! Somebody's stoned. They're not going to be operating under their normal capacities. And again, from our perspective, and certainly from employer's perspective, if there's a loss that's related, and it could be a general liability loss, if you're in a product manufacturing business and somebody is operating a machine that manufactures your product, or they're in a quality control and they're not paying attention to what they're doing because they're high, you're probably going to end up with a poorer product, which could, again, malfunction and result in a claim on the general liability side. Where we see probably most of the claim activity and the danger is on the work comp side, because people who are under the influence of mind-altering substances can cause accidents and injure themselves or others, other employees, or if you're on a job site for a construction contract, somebody else's employees, and cause significant exposure to you as an employer and ultimately to any insurance carrier that's providing coverage. And again, to the extent that we can eliminate drug use, and this particular photo is, I think, during the construction of the Empire State Building, and 1930 or something. And these guys are all sitting on this beam, 40 stories above the ground. And if you see the one guy here there's two guys on the extreme left. I'm not really sure what he's smoking, but in 1930 it was probably a cigarette, but you never know. And if you look over here on the right, this guy's got a bottle. We're not really sure if it's filled with water or, if it was 1930, it might have been moonshine. But, obviously this would be unsafe. Todd's starting to go into a little bit of a cold sweat just looking at the picture. But, again, we care about it because it leads to more accidents and obviously more expense, more injuries, which nobody wants. So that's part of the reason we care. Again, if it's legalized, you're probably going to have more people use it. You're going to have more impaired driving convictions. And again, the test is going to be, how do you prove impairment? And you're going to have, the same, you've seen the videos of guys getting out of their car and they're stumbling around and they say, okay, use the alphabet from Z to A, which I think if I tried to think about it, I might not be able to do anyways. But those are going to be the kind of tests, sobriety tests, field sobriety tests that are going to be utilized in operating vehicles. You're not going to be able to say, okay, this guy's marijuana level was X, therefore he was impaired as a matter of law. But you are going to have body cam or dash cam of people that are going to be involved in automobile accidents or got pulled over by a police officer, and that's where you're going to get impaired driving convictions. Obviously, if it's legalized, you're going to have fewer arrests for selling or possessing marijuana, at least in small quantities. And when you look at the prison population in the state of Michigan, 50% of the people who are in jail are involved in drug-related offenses, typically nonviolent ones, but possession, selling, all those things. So there aren't necessarily, it's not necessarily all bad. There'll be fewer people thrown in jail, which will cost us all a lot less money, and it's going to be taxed. The proposal that is on the ballot basically is to treat alcohol or treat marijuana like alcohol. That's the idea. You got to be over 21. You can't smoke it in public. It's like a 10 or 15% tax that's supposedly going to fix all the roads. Need to be a little higher than that based on my ride over here today. But so there is going to be some increased tax revenue as a result of legalization, assuming it's legalized. But the scary thing is you are going to have more people use it, and you're going to have more people utilizing it in operating vehicles. That's been the story in Washington State and in Colorado. The number of people involved in automobile accidents that are have tested positive for marijuana and apparently are impaired has gone up dramatically, which is scary. I mean, you're drunk driving is bad enough to worry about, let alone somebody texting. And now they're going to be texting, drunk, and high. So, so that part is scary. And as an employer, it's going to be difficult to regulate until there is a test that mandates or determines arbitrarily, in some cases, what level of THC is actually impaired. There's some practical problems. These are just things that I talked to Todd a little bit about. It's like, okay, what happens? You go out in the job market, unemployment is 4%. If you test everybody, and you're looking for guys that are doing work that may not require a great deal of technical skill, if it's a construction laborer or somebody who's doing repetitive work in an industrial environment, if you don't hire people who test positive for weed, you might not find employees. 5 years ago, this probably wouldn't have been the case. You could have said, everybody who tests positive, we're not even going to post offer, we're not even going to have anything to do with. That may not be true anymore. Testing criteria. Okay, so you've got a bunch of guys that, do you test randomly? You might need to if you got DOT regulator, you got safety issues. But if you don't, do you really need to do that? I mean, if you test randomly. And then do you have a reasonable basis post-accident to determine whether somebody should be tested? And again, the real issue is there is no test yet to determine what's impairment and, how high is too high. That's really going to be a significant problem, I think, as a practical matter, absent observable behavior that somebody appears to be under the influence of a mind-altering substance. And the other problem, I think, from a testing criteria, and I think this is generally true, and I'll be curious to see what your response is. When somebody tests positive, you can have a false positive periodically. Typically, the next step is it's retested. That's expensive. And it's a lot more expensive than it is for the first screen. So if you end up with somebody, if you're going to test a whole lot of folks and they test positive because they're engaged in recreational use on non-working hours, it's going to get expensive. And then what do you do with the information as an employer? Do you terminate the employment? Do you not operate or not hire somebody? And there are going to be some problems that I think are going to be broader than simply, we don't want anybody here who's ever smoked weed, which is certainly a prerogative, but there may be some practical problems that make that more difficult to implement. So what can you do? Again, if you've come to the conclusion that you don't want to have even zero tolerance, then you got to have a substance abuse problem, or substance problem. You might have that too, but you want a policy to address the problem, and make sure that it's reviewed so that it's updated and it's consistently applied. And that's really the key. It's consistent application of whatever policy you opt to adopt to protect yourself from some kind of claim of wrongful discharge or discrimination. Again, if you adopt a zero tolerance policy, it's got to be uniformly followed. I mean, I can't emphasize, as a lawyer, I can't emphasize that anymore. Whatever you do, it's got to be done so that you treat everybody the same way, just to reduce the exposure to yourself from a claim. Again, make sure employees, if you've got a policy, they got to know about it. And typically the way that's done is it'll just be, here's the policy, somebody signs for it, and that goes into their employee record. And again, you want to make sure that you have a workplace culture that treats accidents and and people that are involved in it understand what happens in the event of an accident that may or may not be the result of problematic utilization of alcohol, marijuana, or any other drug. And if you have any other questions, I appreciate your time. And there is a policy. I think it's in the back of the materials. It's just a sample that I think is a pretty good policy with regard. This would be, if not a zero tolerance, it would be a pretty close to a zero tolerance policy about, you know what, we don't want anybody here who is under the influence of anything. You could be tested pre-employment. You could be tested post-employment in the event of an accident. Anyways, any questions? Any more questions?
So what happens if the Michigan Supreme Court does rule that marijuana is an acceptable accommodation for disability? How does that change things?
That would change things pretty dramatically, I think. Particularly if the person, and you saw the list of all those conditions, if you have to reasonably accommodate somebody who utilizes marijuana as a drug treatment for the most part, it would be like any other reasonable accommodation, you know, somebody in a wheelchair, somebody who has some other condition. That doesn't mean you have to accept somebody being high at work, though. It would just mean that if somebody tested positive for weed, it would be treated like any other drug that you might otherwise test for. Oh yeah, I've got a script for that. The Supreme Court has said, the Michigan Supreme Court has said that that is something you have to reasonably accommodate as an employer because it's a medicinal utilization of the drug. But that doesn't mean any more than if somebody said they had a prescription for an opioid, you can't have them falling asleep at their desk or at their machine for the same reasons. You have to accommodate it, so you couldn't very well say, I'm not hiring you because you have marijuana in your system, you test positive for it, but that doesn't mean that I have to allow you to be stoned at work.
So we have an employment population that is about 85% DOT regulated, and anytime an employee tests positive, we obviously have to terminate them. They can go through a substance abuse program, and then it's at the opinion of the company to either hire them back or to not. In your opinion, what kind of basis would you say we would want to consider when hiring someone back, and then kind of pushing the lines of like discrimination? If we bring one person back, don't bring the other one back, and what kind of potential problems could lead with bringing people back?
If the only people you bring back are white Anglo-Saxon Protestants, that's problematic. On the other hand, if it's fairly uniform, and let's just assume that everyone is, I've got a great disciplinary record. I tested positive for marijuana. And Todd, I'm going to pick on Todd. He's the worst employee in the whole company. And same situation. You let both of us, you said, okay, you guys got to go to rehab and we might reconsider hiring you. I think in that situation, you could rehire me and say, well, thank God Todd's gone. But if we were both similarly situated, we both had okay, employee records, we don't have absenteeism issues or whatever, and you took him back and not me, that might be a problem. So again, some of it is going to be based on, okay, what would somebody looking at this say? I can see why they didn't hire this person back. I can understand why they hired this person back. It's probably not going to be a bright line. There probably are some, a little bit of black over here, a little bit of white, but lots of gray. So, and again, everybody likes bright lines. The simplest thing to do as an employer would be say, you test positive, you're out of here, you ain't never coming back. That may be problematic because then you may end up with, oh my gosh, we don't have enough employees. So if you utilize that discretion and you can document, this is why we brought this person back. This is why we didn't bring this person back. And you have a record of that. Here's our thought process. This person has a great employee record. He did a stupid thing. And they all know it. If you're DOT regulated, they're not stupid. Well, they might be stupid if they still test positive, but the bottom line is they're aware of what the implications are of testing positive. You're likely going to get fired. And that is, again, if it's relatively evenly handed applied, you have a rational basis for doing what you've done from a rehire standpoint. I mean, anybody with $175 can file suit. But I think the more likely scenario that you'll be successful in defending that would be in a situation where here are the 5 reasons we hired this person back, and here's the 12 reasons we didn't hire that other person back. All right.
Okay, well, that'll do it. Thank you all for coming. There are a lot more pastries and bagels in the back and coffee as well. Also wanted to make you guys aware, we have an event October 11th over at the MSU Management Education Center talking about cyber liability insurance and directors and officers insurance as well. RSVP at the same place, sterlingagency.com/events. Thank you all for coming.
Very good. That's a good group. This is a tough issue. Oh.